Okay, Ms. Flores.
Yes. The Court of Appeals for the 8th District of Texas is now in session.
Thank you, counsel. We are here today on one case, Max Grossman versus City of El Paso, cause number 0819-272 civil out of El Paso County. For anyone watching on YouTube and for counsel, we are holding this oral argument by Zoom pursuant to the Texas Supreme Court's emergency order number 1. The court has had an opportunity to read your briefs. We have reviewed the record, and we've already had an internal discussion amongst ourselves about the case. This is a double appeal, meaning both parties have appealed, and we've combined them together, so the time limits will work this way. Ms. Hobbs for Mr. Grossman will have an opening session of 25 minutes. Mr. Osborne will then have an opening session of 25 minutes, and then each party will have a 10-minute rebuttal period. And the fact that we give you that time doesn't mean that you need to use it all, but you have it if it's available. We have a timing system that's a little bit harder to see than usual. You can see the numbers count down. There's also a lighting system there that will go yellow at 5 minutes and red at stop. Because I probably have a better view of it than you do, I'll be watching it, and if you get to the stop point, I may interrupt you. Not trying to be rude, but we do need to stick to our timetables. So with that said, Ms. Hobbs, we're ready to proceed whenever you are.
May it please the court. The Texas Antiquities Code is a little known and unique statute that the legislature adopted to protect and preserve Texas's archaeological heritage. How did the legislature decide to do this? Well, they made every single Texan a steward of our natural resources. Not just a single state agency, not a governmental task force, but literally every single one of us stewards of those natural resources. Second, the legislature also empowered each Texan with the right to seek protection of those assets in our court system. And I want to start there with the legislative intent and the Antiquities Code itself, because understanding this unique aspect of the Antiquities Code will lead this court to conclude that the trial court was correct to deny the city's plea to the jurisdiction, but irrational and wrong in denying Dr. Grossman's application for temporary injunction. Specific to this appeal, the Antiquities Code declares in section 191.002 that it is the policy of the state of Texas that Native American campsite and habitation sites should be located, protected, and preserved. Those are the precise words of the statute. And that's really why we're here. In October of 2018, new and groundbreaking research indicated the existence of a Mescalero Apache peace camp, if you will, that existed on this record indisputably within Duranguito. This is significant research, and I think this is really important for you to understand because of the Mescalero Apache lifestyle. See, this group of Indians was largely nomadic. That's my word. I think our experts use the word hunters and gatherers, but they moved around a lot. They didn't build pueblos or trade pottery for their livelihood, as many tribes in the area may have done in this era. So to have a camp where thousands of them existed for an extended period of time makes Santiago's research and the book that was published on October 28th significant and an opportunity to study this particular tribe in a way that we have not really had been able to do in the Southwest region. The Mescaleros Apaches nomadic lifestyle also is kind of the heart of what is wrong with the city's scope of work that Mr. Mangum did, and why Dr. Grossman has filed a lawsuit to say that it is wholly inadequate to locate, protect, and preserve the Mescalero Apache remains as is required under the Antiquities Code. Now, I'm certain that Mr. Osborne will get up here and say that the scope of work already takes into account Native American remains, and it does reference them, but it does not take into account this particular type of Native American remains, and that is really the heart of this lawsuit. And if the trial court failed to appreciate that after 2 days of testimony and argument in this case, then that was an abuse of discretion. And in fact, I would posit that there were a few failures by the trial court in this case. And I would want to start with appreciating my burden here. It is not easy to get an appellate court to say that a trial court abused its discretion in failing to issue an injunction. But I think I can give you 3 reasons why the trial court in this particular case abused his discretion in not enjoining the city from starting its project without having an adequate scope of review before the commission. And here's what I would say about that. First, to the extent that the trial court denied the temporary injunction based on a failure to state a viable claim, I believe that the trial court applied too high of a standard. We have a viable claim. We have set forth enough evidence to show a probable right to recovery on those claims. Second, to the extent that the denial of the TI was based on lack of proof of irreparable injury, we believe that would be both legally wrong, inconsistent with Texas's jurisprudence on what we would need to show, and inconsistent with the factual record that we presented to the trial court at the hearing.
Counsel, if I can interrupt you there, can't you read Mr. Mangum's testimony to say that that he's going to go, I guess, as deep as he needs to go until he no longer sees any evidence of kind of human habitation, and he's already been directed by the THC to consider Mr. Santiago's book, and I guess he had looked at it or considered it. I mean, why wouldn't the trial court basically have conflicting testimony on whether the scope of work as described by Mr. Mangum would be sufficient to protect the purpose behind the Antiquities Code?
That's a good question, Your Honor, and you're getting to the heart of what this case is about. But if you look at Dr. Carmichael's testimony about the problems that he has with the scope of work, which is truly the basis of this lawsuit, he finds 3 problems with the scope of work, none of which were really completely defended. There is some conflicting evidence on it, but the 3 problems that he faults the Mangum scope of work with are, first of all, the scope of work does not have a systematic way for discovering this particular type of Indian remains. It's a very European focus, so you'll get a lot of European remains and things like that, but to get to these sort of low visibility remains, his scope of work doesn't have just a systematic way to do it. And then the scope of work, the plan in the current scope of work it's a mechanical excavation of these things. And one of the first things they're going to do is to do some ground penetrating radar so that they can find remains underneath the surface. And again, that's great for finding European remains. That's great for finding even possibly like pottery and things like that, Native American remains that are different than the kinds of remains that you would find with this type of tribe. But the radar penetration will not find these low visibility remains, according to Dr. Carmichael and the testimony that we presented to the trial court. And then finally, one of the things that's definitely not addressed by Mr. Mangum in any way, shape, or form is the scope of work's decision to use a 1/4 inch screen to, when you pull out the remains, it's screened through certain sizes of instruments. And the scope of work anticipates using a quarter screen mesh in order to find those remains. But Dr. Carmichael has noted his opinion that that would be insufficient to find low visibility remains. He did a study with his students on a particular site, and they found that 90% of the remains were not found using a quarter-inch mesh, and they would be found if you included it, if you used a 1/8 of an inch mesh like Dr. Carmichael recommends.
Were those issues raised in Dr. Carmichael's affidavit that was sent to the Texas Historical Commission, I guess, in August, September of 2018?
I believe I would like to brief you on that specifically. I don't have that letter right in front of me, but the gist of those complaints were definitely presented to the THC2, but I don't know if, obviously we went through discovery and other things in this case after we amended our petition. So Carmichael's opinions might have gotten more specific through the discovery process than what was originally presented to the THC. I honestly don't have that letter in front of me, and I can't answer that question with the honesty that I would like to.
And it really raises my core question, which is, if these issues are raised to the THC, which is an agency that I would think has expertise in these areas, at least far more expertise than I have, why wouldn't we defer to them? Maybe almost like a Chevron or our deference.
Well, I mean, let me just say, for Chevron purposes, it wouldn't come into play because this isn't a lawsuit from a actual act by the agency. But it goes back to my opening, Chief, and it's just the Antiquities Code is unique. No one doubts that the THC had the authority to require the city to redo their scope of work based on this new research that was not at all, no one knew about it when the city first applied for their permit. But to say that they have authority, there's nothing in the Antiquities Code or in their enabling statute that gives them the exclusive authority. And in fact, as I mentioned in my opening, the Antiquities Code is unique in that it does make us all stewards of our archaeological heritage. It makes me a steward, Dr. Grossman a steward, you a steward, the trial court a steward, and that's its intent. Is these are precious assets, and we all have a role in protecting them. And the Antiquities Code itself gives us all that, not only obligation, but the ability to make sure that they're protected. One of the things, going back to just the standard on why I believe that there is an abuse of discretion in this case, is to my third point. I listed number one, the trial court either got the standard wrong on what we needed to show probable right to relief and a successful claim. Two, on irreparable injury. And then the third is that the trial court abused its discretion in failing to balance the equities of this case. And the case that we cited in our brief that is a good case is the Seaborg-Jackson case out of Dallas from 1988. And it recognizes that a trial court who doesn't do, an injunction, a temporary injunction or a final injunction, those are equitable remedies. And because they're equitable remedies, they require a balancing of the equities. And in Seaborg-Jackson, the Dallas court did find that a trial court abused its discretion in not considering the equities of this case. And that goes to the overarching question for this court is, did Dr. Grossman do enough to show that his claims are likely to succeed on the merits, enough to show that we should get a trial on the merits? This was a very short and rushed discovery on these claims. We believe we can dive into this more deeply and have a trial on the merits. And the question right now is, should we keep the status quo right now, like where the city is right now, where we are right now, so that we have an opportunity to go to the trial on the merits? And the balance of equities in this case certainly suggests that we should. If we commence this project in any way, even with the demolition of the buildings, the testimony at trial indicates that we could disturb these archaeological remains. Mr. Mangum says so in his scope of work. He says that it could have been, we could unintentionally disturb these remains. Dr. Grossman, who has an archaeological background, says that yes, demolishing buildings with this big equipment can disturb the soil underneath it enough to lose these remains of the Mescalero Apaches. And Dr. Carmichael said that if Mr. Mangum is correct about the depth of these Mescalero Apache remains, then yes, using huge equipment to demolish these buildings could in fact put the archaeological remains underneath the soil at risk.
Ms. Hobbs, I have a question, and maybe it's going to return you back to the questions that Chief Justice Alley was asking. We have concerns, I believe, like how do we stay in our lane as the judicial branch, as opposed to disturbing the role of the Texas Historical Commission, meaning that they've already gotten involved, they've already received a great deal of this evidence, not so much in the testimony itself, but I suppose in the declarations that were submitted. And then they responded with a letter that seemingly accepted the idea that the research was substantive, because they added at least one sentence that I do have in front of me, in which they informed the city that the permit has now been reinstated, but they also say to the city, we recommend that you familiarize yourself with Mr. Santiago's work and consider the potential for encountering cultural deposits associated with the peace camp during your investigation. So in that sense, it does seem like some relief was granted by the Texas Historical Commission to somewhat incorporate this new discovery. And so I guess I'm getting back to trying to understand the structural role of the Historical Commission and our role as a branch of the judiciary. And how is it that we don't step into their discretion?
Right. Well, I would say two things. One, the legislature has told you what your lane is, and your lane includes under section 191, 173A, your lane includes granting injunctive relief to restrain and enjoin violations or threatened violations of the Antiquities Code. So the legislature has given you this lane. And secondly, the THC, we went to the THC hoping that this groundbreaking research would prompt them to require the city to redo their scope of work to make sure that it would incorporate means necessary to protect and preserve these specific types of remains. And given this idea that now we know they're in Duranguito, but they didn't. But I'm not here to review the THC's decision on that. We had hoped we could avoid litigation by going to the THC first, but we're not here to force the THC to redo a permit or anything like that. The city itself has to comply with the Antiquities Code, and it's the city who now has submitted a scope of work that is inadequate to take into account its own duty under the Antiquities Code to protect and preserve Native American remains, and particularly in this case, the Mescalero Apache remains. So our relief that we're seeking has nothing to do with the THC. We never asked the trial court to force the THC to withdraw that permit or in any way do that. What we're asking is to have the city present a scope of work that makes sure that the scope of work is adequate to protect and preserve the Mescalero Apache remains that we now know are in Duragato.
But the scope of work, go ahead, Justice Palafox.
I just wanted to follow up. So you mean that they would modify their scope of work and then have to resubmit it back to the commission?
They would, and they have. So that's not unusual that you modify your scope of work to the commission. Usually it would be at the commission's request, but they can, and in fact, even their own scope of work anticipates that they will be going back to the historical commission and sort of getting reapproval as they learn more. And this is just another step in it. Now they know about this unique opportunity to study these remains. And they're, to be honest with you, Judge Palafox, they're, and I have no qualms with Mr. Mangrum and his entity that does these kind of work, but he has never dealt with this type of Indian remains, these low visibility remains. He has no experience doing it. He has not gone to El Paso to learn more about how he could do it, where it might be. He candidly admitted that he has no intention of changing his current scope of work, which is wholly inadequate. And that's the city, that's on the city. The city has its own obligation to protect and preserve the Mescalero Apache remains. And that's what we're here to do, is to force the city and its agent, Mangrum, to provide a scope of work that is actually going to preserve and protect the Mescalero Apache remains as the Antiquities Code requires it to do.
Okay, could I have one more follow-up on that? Justice Alley, sorry.
Absolutely.
Okay. I know I was stepping on your other question.
No, go
Okay,
ahead.
so when you're describing this desire to have the city modify its scope of work, we're talking about a document, correct? And it seems as though, is it Dr. Mangum?
No, he's Mr. Mangum. That's the city's expert.
So Mr. Mangum, in his testimony, to the extent that he reacted to some of these criticisms, in my view, he seemed to suggest that he would plan to incorporate some of these concerns about looking for this particular Apache Peace Camp as he did the project, as he performed the work. So I guess what I'm saying, you have the document itself, which is the scope of work, and then you actually have the in the field, on the ground work that he's doing. So why can't we just accept that he's making a promise that he will take into consideration this Apache Peace Camp as he performs the work on the ground, regardless of what the scope of work currently looks like?
So both experts, ours is Carmichael and the city's is Mangum. I mean, they both do, to be frank, they know that excavations like these, they do advance and progress and things like that. The problem is that scope of work shows what he's obligated to do under his permit. And if it is inadequate, and he, I hear you. I'm not saying Mr. Mangum would not act in good faith, but if he's not required under his permit to take these steps to make sure that in fact he does protect and preserve, he does locate and protect, or I'm certain he would preserve them if he found them. So it's mostly locate and protect. Those remains, that he would do so. The problem is that he has no systematic way of finding them. His approach does not take into account the low visibility remains that the Mescalero Apaches. So his approach would be fine if there's pottery from another tribe or, you know, just these high visibility things that you can find them with that radar penetrating location. You can even figure out how deep they are. But these particular remains are so unique when you have a tribe that was nomadic like that. They're just, you've got to be systematic. You've got to figure out what your trenches are. His trenches and his scope of work are only going to go down 2 feet. And we believe that they're likely to be much deeper than that. And so his scope of work, it's not just, oh, we'll try to do the right thing. It's like, this is what you've said you're going to do. And it is wholly inadequate to account for this type of remain. And that's a problem. So promises are promises, but the scope of work that's their blueprint for what they're planning on doing. And if their blueprint is completely inadequate, it's like a doctor saying, you know, I'm going to try to figure out what's wrong with your body, but I want to hear what you're trying to, like, what tests are you going to perform? What, you know, how are you going to systematically figure out where whatever symptom could be? To say, oh, we think doctors act in good faith, that's not sufficient. And if I could just say this to Justice Halifax, if we aren't required to prove at this stage of the litigation that in fact, that scope of work is inadequate. That seems to be the burden that the city wants us to do. Their response is, hey, Mr. Mangrum says he's going to do all he's going to do. And Mr. Mangrum says he'll think about these things when they come through and blah, blah, blah. And all we have to show is probative evidence that we could succeed on this merits. We can dive into these matters more significantly as we go to trial. But right now, the question is, did we show enough to be concerned that the status quo has to be maintained lest we lose significant archaeological findings in the state of Texas? And it's not that we have to prove our case. It's not that we have to conclusively prove our case. We think we have done enough to show his scope of work. And Judge Halifax, in the end, if the court says, you know what, I trust Mangrum and he's going to do his best, but that's what the remedy would be at the end of a trial on the merits. But right now, we're just saying, have we shown you enough that our claim is legitimate and that the case law demands that we get an injunction right now to maintain the status quo so that we can continue to have this discovery and what has to be done and what is the intent with the scope of work and the project.
Thank you, counsel. I see your time is up.
Sorry, thank you. I did not see it. So thank you.
I know. Like I said, I may have a better view of it than you do. Mr. Osborne, you may proceed.
I'm pleased to court and counsel. Let me just address a couple of the issues that were raised in your questioning and in discussion with Ms. Hoffman. And the first is, if there, at any time, if there is additional evidence that Dr. Carmichael or anyone else has, they're welcome to present that to the THC. I believe everything was presented to the THC, but this is not, they can approach the THC at any time. They can present additional evidence. They can ask for modifications and revisions. And we will, as Mr. Mangum said, the city and more will follow all of the guidance we receive from the THC. That's all we can do because we have to follow that guidance. We can't go outside of it, but we will follow whatever guidance they give us. And so that process of dealing with the THC doesn't end. It can be picked up by Dr. Grossman, Dr. Carmichael at any time, and they can present additional evidence. The THC will respond as it did prior to this lawsuit being filed. So I would like to begin by consideration of the big picture. Here, the city followed the Antiquities Code. It was told to apply for a permit for an archaeology survey. It did that. It hired more, a respected archaeology firm who's had numerous dealings with the CHC and THC and worked with them on numerous surveys around the state. prepared a research design, prepared a scope of work, submitted it to the THC. The THC reviewed it. They have archaeologists on staff, including the state archaeologist, the highest archaeologist in the state. They reviewed it and required revisions. Laura went back and made those revisions, submitted a revised scope of work, and that's what the THC has approved. And then the other important thing is to keep in mind the big picture here in terms of the survey. We are looking for Native American artifacts, but not only Native American artifacts. We're looking at artifacts from all periods of time. Ms. Hobbs again misstated. She did it in her brief and said that Mangum said he was only going to go 2 feet. She's now, and she recognized that mistake in her reply brief. She's now made the same mistake again. That was a theoretical example he gave to doing if you're going to build a road, you might go 2 or 3 feet down. He said they will go to the depths or deeper than the anticipated excavation for the facility. You don't need to go deeper than that because whatever else is there will still be preserved, but you have to go as deep, and that may be 30 feet or more, and more in areas, for example, where there are pillars and things or foundations. But you will go to depths of 30 feet or more in doing this excavation, but you have to look at all of those depths from just below the surface down to the bottom.
Mr. Osborne, if I may interrupt for just a minute. So let me ask you, let's say hypothetically, you know, there are these archaeological remains and the Historical Commission gets it wrong. So I guess the question is, so Dr. Grossman brings forth this suit or the plaintiff brings forth this suit, does the court have the authority to review and get down into the minutia of the Historical Commission to determine whether or not they made the right or wrong call?
With all respect due to us as lawyers and judges, the simple answer is no. The court does not have the jurisdiction to review the decision of the THC. It's a discretionary matter left to the THC to decide. And what Ms. Hobbs left out of that description of this section of the statute that is the basis for Dr. Grossman's claim, which is 191.173A of the Antiquities Code, it permits suits by citizens to enjoin threatened or violations or threatened violations of the Antiquities Code, which is Chapter 191 of the Texas Natural Resources Code. But what it does not allow, because it would have to expressly state it, is a suit against the state or a subdivision of the state. There's no waiver of governmental immunity.
Okay, so let me stop you right there for a minute. Because the problem I have with that argument is governmental, let's say we have a governmental entity who comes in and clearly there are archaeological remains and they destroy them and they're going to destroy them. They don't go to the Historical Commission. I don't know, regardless of whether they go to the Historical Commission and get a permit or not. So then you're saying that the right was given to every Texas citizen against any private landowners, but publicly held land, they have the unfettered authority to destroy whatever they choose to.
You mean, I'm sorry, but do you mean a governmental actor?
Yes.
A city on its own land?
Yes.
Okay. A suit could not be brought under this statute by a private citizen. The THC could bring an administrative action to stop the city because it does violate the code, and that would be done internally as an administrative matter. It's not that they're immune, but citizens are not authorized under this statute to stop governmental actors like that. That's true in a whole variety of cases. There's governmental immunity as a general matter, unless
don't misunderstand me. Don't mistake me, Mr. Osborne. I fully understand the idea of sovereign immunity. It's just difficult for me to envision that this Texas Antiquities Act is only to apply to private landowners, because then it doesn't further the purpose of the act, which is to protect
Oh, it
those
does.
antiquities.
It
It
does.
doesn't seem rational to me.
Here's the test. The test for deciding, so there's no question there's not an express waiver of sovereign immunity. That
Right.
language is not present in the statute. Grossman's argument is that the court should imply it. The test for implying a waiver of immunity is the statute meaningless without it? Here, and we're talking about the entire Antiquities Code, all of Chapter 191. Chapter 191 prohibits the removal, altering, damaging, or excavating without a permit or in violation of a permit, shipwrecks and their contents, buried treasure, historical artifacts on state land, and that would be by someone going on to state land to do it, a private party. The statute also prohibits defacing artifacts, monuments, historical structures, and Native American paintings or carvings. All of those prohibitions could be violated by private actors. And so the statute has meaning because it allows any citizen of the state of Texas to go in if someone is doing that and get an injunction to prohibit those violations. Thus, the statute has meaning. What Grossman's argument really is that the statute will have broader application if you apply a waiver. But that's not the law and that's not the test. And the reason is, if that were the test, you would always imply a waiver because every statute will have broader application if you have a waiver of sovereign immunity. But the test
Counsel.
is, yes, Your Honor.
Well, I guess the hypothetical, just to kind of put it in real terms, is, let's say this city or some other city, I'm not impugning anybody's character, they're building some water park or something like that, and they come across what looks like to be the next Keystone site. And what if this absolutist position on immunity is true, why wouldn't a governmental actor say, well, it's better to ask for forgiveness than permission, so I'm just going to go ahead and bulldoze the site first because I've got immunity? Because I thought what you were going to answer is, if a governmental actor did something as brazen as that there'd be an ultra vires claim against them.
Well, there could be. If you were actually acting outside the authority of the law, there can be an ultra vires claim. I was thinking more of not necessarily someone going out and literally just intentionally violating the law, but there being a dispute about what would be the nature of how we should do the investigation or something, or should we apply for a permit or that kind of thing. I think that in the context of an administrative action. But certainly if an individual were acting outside of the authority of the law, you could bring an ultra vires claim.
The bond validation.
I'm sorry?
The bond validation suit that was first filed in Austin, I think that would be termed an in rem action because it deals with the project and not so much the individual parties. Is there any way to characterize this litigation, the injunction litigation, as an in rem proceeding?
I don't believe so, Your Honor. This is a suit against individual actors. And the reality is, even the bond proceeding is the ex parte City of El Paso suit. It's an in rem action in reality because the legislature created it as sort of a legal fiction as a means of dealing with bond projects and getting them approved and having a legal theory by which you could draw in all the interested parties, which happens in that kind of a suit. You give notice and then anyone who wants to intervene, that's your one shot. This is really not that kind of a matter and certainly hasn't been brought that way.
Mr. Osborne, I have a question. I happened to come across a case last night in getting ready for this argument, which I don't think I read it in the briefs, but maybe I did. It's been a while, trying to digest all this information. But the case I'm thinking of, and I'm wondering whether you think it's persuasive or not, is Sweeney versus Chief Justice Jefferson. And in that case, it's actually the Texas Supreme Court building itself had two plaques that were placed there regarding the origin of the building and the fact that the building was built with funds from Confederate soldiers' retirement funding. And at some point, Chief Justice Jefferson, or maybe even his predecessor, and the executive director of the buildings, they ordered through maintenance to have the 2 plaques removed and replaced by a newer version of the plaques. And in that case, the jurisdiction, the subject matter jurisdiction under the Antiquities Code was accepted and established by the court. Although a little bit more so because the parties were conceding that jurisdiction. So I wondered if you have the Texas Supreme Court justices along with the building maintenance director, which is actually state property procurement officer. If they're making an effort to remove a plaque from a historical building, and yet the Antiquities Code does have jurisdiction, and an injunctive relief is allowed in that case, why wouldn't that be persuasive authority to this case?
Honestly, Judge, I have to tell you 2 things. I certainly would. Ultimately, the Supreme Court decides what it can and cannot do. No question about that. I do remember that case, but I honestly am not familiar enough with it to address it with respect to this issue. The case that I would say is very similar is the Bacon case. And I will address that with the court, that in the Bacon case, the issue was there was a dispute about the language on a historical marker. And the Austin Court of Appeals in the Bacon case said, that is a dispute solely within the discretion of the THC to decide what's the right language to put on the marker. And you can go to the THC and you can present all of your evidence, but they're the ones with the exclusive authority to decide that matter. And it is not subject to judicial review. And I would say that is the same pattern or same situation as in this case. Archaeological disputes are solely within the decision-making, the discretionary decision-making of the THC. And Ms. Hobbs is incorrect about one thing. What the relief requested here is actually relief requesting the city to do an illegal act. The request is that we prepare a revised research design and a revised scope of work, and then proceed and do our survey under that revised scope of work, because their contention all along is we're not involving the THC at all. We don't want to have anything to do with them. We don't want to modify their permit. We're not doing anything like that. If a court were to order the city to do a revised research design and a revised scope of work and then proceed under that revised scope of work, the city would be in violation of the Antiquities Code, because the Antiquities Code statutes require that we follow and comply with the THC's permits. We can't act outside of that permit. So
well, isn't that argument then suggesting that the Antiquities Code does govern this project? Aren't you conceding that point?
Absolutely, the Antiquities Code governs it, but in this case, who issues the permit, who decides how the archaeological survey is to be done is the THC. They have wide discretion in that matter.
So let me ask you, Mr. Osborne, if the THC, if the argument is, and the proof supports that the THC abused their discretion, then what does a private citizen, what is a remedy?
I'm sorry, some of that broke up, but if I understood.
That's my fault, I apologize.
No.
If the allegation is, and the proof was that the THC abused their discretion, you said it was, Bacon stands for this is within THC's discretion, but what if they abuse their discretion? Then what rights does a private citizen have under the Texas Antiquities Act?
Let me, Your Honor, you ask a great question. Let me answer it for you by reading the conclusion from the Bacon case, because I think it is exactly the conclusion that you all should reach in this case. And I apologize, it'll take just a minute, but it's really worth listening to word for word. because it's exactly what you're asking. The conclusion the court writes there is, were we called upon to decide, at least on this record, whether the current official Texas historical marker at Mount Bonnell is entirely accurate, or if the factual assertions within it are supported by legally or factually sufficient evidence of the sort that a fact finder could properly rely upon in court, we might well conclude that these are close and difficult questions. For that matter, we might well conclude the same thing about Bacon's competing version of history, which rests upon a succession of inferences derived from circumstantial evidence that is now almost 2 centuries old. But this is not a dispute into which the Texas judiciary has the subject matter jurisdiction to intervene, and that is what controls our disposition of this case. Then listen to the last thing they wrote. In this respect, at least, the outcome of this appeal would be the same, even if the Mount Bonnell historical marker had stated that Bigfoot Wallace had encountered not only the Indian he killed nearby, but also Christopher Columbus and dinosaurs. The prospect that the THC would actually approve such a text in an official Texas historical marker is presumably unlikely, one hopes. But if the agency were ever so inclined, the checks and balances found elsewhere in the executive branch and in the legislature might well give it some pause. Likewise, it would remain the legislature's prerogative within constitutional constraints alter these checks and balances, including and not limited to providing the additional check of a judicial remedy. It is such mechanisms of the legislative and executive branches, not in the judicial branch, where Bacon's remedy, if any, would currently lie. And I believe that's the exact answer to your question in this case. If the THC does something that is so far out of the bounds, the remedy is to go to the legislature or to the executive branch for Grossman. If the legislature saw the THC were acting so far out of its appropriate bounds, it could grant a waiver of sovereign immunity and allow judicial review. That is not the case at the present time. So the only remedy Dr. Grossman has is to go to the legislative or executive branches. This is not an area that is appropriate for judicial review because the courts do not have subject matter jurisdiction over this dispute.
So Mr. Osborne, I guess I don't know if my question is pretty broad, but I guess what I'm wondering about is that it seemed as if Mr. Mangum did testify that these are new discoveries being brought to his attention, and that when he's in the field and on site, he would take them into account. So I'm just wondering, what duties, if any, does the city have to incorporate or modify or change the scope of work and report that information to the Texas Historical Commission when there is a bit of concession that the original scope of work was drafted at a time that this particular information wasn't as well known?
And actually, I think that's the nature of the dispute between Dr. Carmichael and Mr. Mangum or Moore, archaeological consulting. It's not that the scope of work or report is ineffective or inaccurate. What it is, it's broad, it's adaptive, and it's flexible for exactly this purpose. Dr. Carmichael proposes that he would have in a scope of work the exact procedures for finding Native American artifacts. The problem is we're not just looking for Native American artifacts. We're looking for all sorts of artifacts. That's one of the reasons you need ground penetrating radar. Even if they're not effective for Native American artifacts, they are going to be effective for other artifacts from other eras. So we still need to demolish the buildings. We still need to do the ground penetrating radar first. And then what the scope of work provides is that it's broad, it's flexible, it's adaptive based on what they find as they go, and in consultation with the THC staff, which they will be doing throughout the survey, and based on their own experience and judgment, that is, of the archaeologist on the ground. Dr. Carmichael said, what I don't like is it's just too broad. I want more specifics. The reality is we don't need more specifics because it's going to change as we go down and as we consult with the THC. There's nothing wrong with the plan. It's going to find the Native American artifacts. And there may be more information that comes in the next few days or in the next few months. And all of that information will be taken into account. Mr. Mangum was already aware of Mr. Santiago's book before Dr. Grossman raised it. It had been published in October of I believe it was 19. He was already aware of it and had begun becoming familiar with it. More research may always come out, and Mr. Mangum and Moore will take those into account, and the current scope of work allows them that flexibility and adaptability. These are archaeologists. They want to find remains. This is not where some city manager wants to tear something down to get a new project built. Moore's reputation is built by finding archaeological remains, and then they write papers and preserve them. That's their reputation. That's how they get to be well known. Carmichael and Mangum are equally passionate about this. Their whole goal is to do it. The only difference is Carmichael would do a very specific scope of work with all the details to find one strata of remains. Moore is writing a broader report that's going to look for remains at various strata, and that will be varied depending on what you find as you go. The scope of work doesn't need to be revised. It's already going to take into recommendations, and if the THC were to make more recommendations, more will follow those. So that I think that's exactly correct. There's no need to change anything now. And this brings me back to a point. I'm trying to see how much time I have left.
Minute 40.
Is it 40 seconds?
No, 1 minute and 35 seconds.
Okay, let me see if I can do this really quickly because it relates to your question about finding new evidence and taking it into account. Grossman's claims here are barred by res judicata from the Grossman versus Wolf suit. And just because there seems to be some lack of understanding by Grossman that he was adverse to the city in that suit, I'm reading from the case in Grossman versus Wolf, and the court began its opinion by saying, as relief, Grossman asked the district court to declare the permit void and to enjoin the city from conducting the archaeological survey authorized by the permit. It is exactly the same relief in this case. And what he brought in that, so when he's saying, I want you to enjoin the city from proceeding with the archaeological survey under the permit, he's now saying, I have new evidence as to why that should happen. And if you look at the case of Barr versus RTC, I'll find you the site here in just a second, but it's a case dealing with both issue preclusion and res judicata. And in that suit, what happened was there was a suit against a guarantor on a note. The guarantor was found to be not liable. Later, a suit was brought against the same person because he was a partner in the partnership that was on the note. And the Supreme Court said that's barred by res judicata because you could have brought it in the same case. Here, Native Americans, their presence was known before this case started, before the Santiago book. This is like if you said, well, he signed the note as a partner. So we knew as a partner, but now we have the partnership agreement. We have new evidence so we can bring the claim. The Santiago book is not new evidence. It's just more evidence. This claim could have been brought in the first case, and the claim about demolition was brought and decided in the first case. So both of Grossman's claims that the statutes have been violated are barred by res judicata from the Grossman v. Wolf decision. I'll stop there because I see I'm out of time.
We actually have 40 seconds left, but
Oh, well, let me stop there and I'll yield my 40 seconds, Your Honor.
Okay, thank you, counsel. Ms. Hobbs, rebuttal.
Oh, use a microphone.
Oh. Should be muted.
I had muted myself because my dog opened the door, but my cat is running around here like crazy. So if you hear her playing with the strings on the windows, I'm sorry.
Okay, and if you'll hold on 1 minute, there we go. We had to get our clock right, but proceed.
May it please the court. The city's position today before this court and at trial before the trial court is the same. It's trust us, trust us. But it, when I listen to Mr. Osborne argue this, it reminds me of what a jury, what the city might present to a jury if we were on a final trial on the merits, deciding whether the scope of work was actually inadequate. But that is not the burden here today. Our burden was just at the trial court, and our burden to show that the trial court abuses its discretion is, did we show probative evidence that showed a likelihood of success on the merits? So this idea of trust us, trust us, trust us, that is just self-serving conclusory testimony. And we put on multiple witnesses at this trial that showed that there is a probable violation or threatened violation of the Antiquities Code. And that was our sole burden. That's all that we had to do. I wanted to analogize it a little bit, and I'm always nervous about doing analogies on the fly in an oral argument, but it's like if the employee who left a company with confidential information said, hey, there's no need for an injunction because trust me. I mean, I know I have this information, but I'm not going to do anything with it. I feel like that's pretty analogous to the conclusory nature of what the city is saying. But more to the point is that this is all about whether we did probative evidence to show likelihood of success on the merits. We did not have to conclusively prove that this scope of work was inadequate.
Counsel, let me return you to the jurisdictional argument, if I may. Is section 191.173 the only statutory basis for which you're claiming governmental immunity is waived?
Yes.
Okay, so that statute says that you may file an injunction, but it does not specifically mention government actors. That's correct, right?
That is correct that it does not, that particular section does not mention governmental actors.
So tell me how it's different than section 442.012 that was at issue in the Bacon case.
If I can just back you up for just a second, Chief Justice, about what the standard is for when a statute might waive immunity. The Texas Supreme Court has acknowledged that there are statutes that waive immunity that are not, quote unquote, a model of clarity. What I read that to mean is this idea that Mr. Osborne is pitching to you, that there needs to be some magic language in order to waive immunity. That's just false. The Texas Supreme Court has says it does not have to be a model of clarity. What they're looking for is legislative intent that would provisions of the statute be completely meaningless if the provision of enforcement did not serve as a waiver of immunity? I think in Mr. Osborne's view, if he can think of one scenario where you can imagine a lawsuit between a private citizen that a plaintiff would bring against a private citizen, that's somehow the test. But I can't find any case law, he has cited none, that actually support that view. The question is all about legislative intent. This statute, although it does not say immunity is waived, this is about as express of a statute as you can get for a waiver of immunity. It is saying every state and every person in the state of Texas has the right to go get an injunction. And more to the point, and to directly answer your question, Chief Justice, is why is it different than chapter 442? Sorry, I may be getting my other provision wrong. The Bacon, statute that was addressed in Bacon, I think it was 442 of the government code. So keep in mind, in Bacon, they were looking at a statute. It's really the historical commission's, it's their enabling statute. It's a very broad statute. And what the plaintiff in Bacon was looking to do, it was looking to use that provision, and I'll confess, they're similar languages. You can see them side by side. What they were doing is trying to seek review of a state agency decision through that. And the court said, no, we're not going to do it. This is a broad statute. I will say, I know I characterized that opinion as not well reasoned. it's a very difficult opinion. The plaintiff had started off pleading as a pro se. So you kind of see the court, let's take give him every, and it becomes kind of a muddled mess. I really believe that. It's Justice Pemberton's opinion. I respect him so much, but it's hard to follow all of the opinion, I think, in part because that plaintiff was pro se. But what I will say about the differences between Bacon and the statute in Bacon, the enabling statute for the THC, and this statute is the entire premise of the Antiquities Code is to protect remains on public land and to ensure that the governmental entities who own these public lands also protect them. That's the point of the Antiquities Code. And so to compare these two statutes, an enabling statute and a very specific statute that expressly apply, like it expressly says municipalities have duties and obligations under this statute. And then to say, oh, you can enforce it, you can sue to enforce it, but only to private actors and not to public actors. Like it would totally.
But I mean, if the municipality just totally ignored it, but they would be subject to an ultra vires claim, and which in fact, I mean, you effectively brought that in Austin in the Wolf lawsuit.
Well, true, and I lost. So I mean, that doesn't give us. I mean, if you and I appreciate your example of just a brazen non-compliance with the statute, in part because I feel like the city did that originally. I mean, if you remember, this lawsuit started because the city refused to even give the THC notice of a 5-acre public project. So I do think there's some brazen disregard for the Antiquities Code on the part of the city of El Paso, but putting that aside, this statute, the chapter 191.173 would have zero meaning if the point is to protect our heritage that exists on public land. That's what the whole statute is. We understand we have these public lands. We understand we're going to have this development on public property. We want every citizen to be able to go in and protect any heritage, archaeological remains that might be in those things. And if the government isn't doing their job, city, you can do your job. And that's very different than, we don't like the way a marker is. We went to the THC and we said this marker should be reworded this way. And so we're trying to get around any kind of judicial review under the Administrative Act. And so we're going to go up under the statute. That's not what this is. And Justice Rodriguez, I want to go to your point too, because I appreciate where your thought is going of like, what happens when the THC just makes really bad decisions? I don't know the answer to your question, but what I do know is that this lawsuit is not about a decision that the THC made. So we are not looking for review of a THC decision. And I just really want, even though I appreciate where you're going with that's not what this lawsuit is about. This lawsuit is about the city itself has to do a scope of review, submit a scope of review that does in fact comply with the Antiquities Code. And I know I'm speaking fast because I'm at yellow light, but that goes to Mr. Osborne's thing, is that we're asking them to do an illegal act. That argument is not well thought out. First of all, we are not asking them to do an illegal act. We're asking them to resubmit a scope of review to the THC for approval. We're not asking them to go out and do something, but more importantly than the relief that we're seeking, what Mark Osborne is conceding when he says that is it undermines his entire, hey, trust us philosophy of this case. If we're just trust him and that he did these broad adaptive things, why would saying, hey, revise a scope of review to actually account for what we now know is under Duranguito, how could that be an illegal act? So he's either being completely inconsistent or not forthright with the court, but either way, it doesn't really lend itself. I want to touch on one factual issue, and I may not get to the res judicata because I feel like my briefing may speak for itself on the res judicata account, but Mr. Osborne has noted that I am misrepresenting how deep the project is going to go. Let me say, Mangram's opinion is that he's going to have to go as deep as he's going to go. But he doesn't say what it is. He refuses to answer any questions about it. But what his scope of review says, and this is at 5 RR 16, is his trenches are going to go 2 feet. So whether he was talking about a highway or answering a hypothetical on the thing that Mr. Osborne says I miscited to the thing, I will just point the court to that additional site that's actually in the scope of review. And I know my so thank you.
But Council, I did want to ask you one question before we switch over. The city has filed a motion for this court to modify its, I guess, our grant of an injunction to protect our jurisdiction. And their alternative form of relief at the end is, if you're not going to take that back during the pendency of this litigation altogether, at least let us go ahead and take the buildings down. Because as I understand the testimony, I mean, your theory is that these remains are at 17 to 20 feet because there's been all these alluvial sands that have accumulated. So if that's the position that your experts are taking, why wouldn't we just go ahead and let the city take that first step, and then maybe if it's our determination that you need to make this systematic process, you go ahead and do that, but to get the buildings out of the way first, because they're going to have to be gone to do the
I think this is an important question. I hope you'll grant me a little leeway, even though my time is up, to answer it, because it's really important. And it also goes to the whether the trial court abuses discretion, and if the trial court found no irreparable harm, whether the trial court abuses discretion in that. And let me say this, their own, and I just got through saying like their own expert, and we disagree about what exactly he said about whether it's 2 feet or 3 feet. But we do know that this is going to be a machinery excavation. This is not, we're not talking about, and the buildings too are going to come down with big machines. And so if the city's own expert is correct that these remains are in a shallow level, because remember, Mangrum disagrees with us about how deep he needs to go. So I asked our expert, well, Mangrum's right and it's shallow, then would that could that potentially disturb remains? And our expert, Dr. Carmichael, said yes, it could. Our Dr. Grossman, who also has an archaeological background, testified that demolition of the buildings could in fact impact low enough in a stratosphere to impact these remains. And then I just want to, and I just saw this morning as I was going back through the scope of work, and this record site is at 5 RR 36. And Mr. Mangrum, in his scope of work, admits that it is possible that the machinery involved in the demolition may unintentionally expose archaeological deposits. So that's at 5 RR 36. But if I could just make one broader statement, in addition to giving you that evidence about why it's important that we do not start demolition because we're worried that they will actually harm the remains, subsurface remains, is that the question before this court and before the trial court is, are we entitled to the status quo? And the status quo is those buildings are up, nothing's getting harmed, let us go to trial, let us maintain the status quo. And that is actually the legal question before the trial court. And the review question before you is, was it an abuse of discretion to not maintain the status quo? But the status quo is actually what we should all be focused on, not what is the form of relief. And in fact, you could find that the trial court abuses discretion in not giving us some form of relief. And because he didn't give us any relief, we don't know what relief he might give us. So it would be premature for us to be deciding. In other words, just focus on the status quo and whether the trial court abused its discretion in not maintaining the status quo. And maybe Mr. Osborne and I will disagree about what the status quo is when we go down to the trial court. But for now, that is the legal question before the court. And thank you for that liberty and some time on that question.
Thank you, counsel. And Timekeeper, if you can give Mr. Osborne 15 minutes to kind of compensate with the understanding that he'll answer that same question that I propose that I ask at the end. So go ahead, Mr. Osborne.
Let me begin by addressing that. To be clear, what Mr. Mangum said is it is possible that when you demolish buildings, that there could be some disturbance of artifacts immediately at the surface. The THC has required, one of the revisions in the scope of work to account for that is that Moore has to have an archaeologist on site during the demolition. Mangum will be there. And his exact purpose is, if anything happens during demolition that would disturb any artifacts, they will stop the demolition in order to locate, protect, and preserve those artifacts before it continues. So all of this is adaptable and accounted for. And again, the only artifacts that would be disturbed are those right at the surface. Mangum does not believe that the Native American artifacts are right at the surface. What happened in the dispute in the testimony is that Carmichael basically is very certain that those Native American artifacts will be somewhere between 12 and 18 feet below ground based on flooding from the Rio Grande, in historical times. Mangum simply said, I'm not so certain what the depths will be. They'll be there somewhere. I just don't know if they're that low or not quite that low. In any event, they're not going to be anywhere near the surface, so they won't be damaged by demolition. And to read for you the quote of Dr. Carmichael, his testimony cited at 2 RR 87, his quote is, tearing down the buildings will not affect the artifacts below ground, period. That's his testimony on the subject. So I don't believe there should be any injunction, but if there were any to continue or any stay from this court, it should be simply a stay at the best, not do the survey, or maybe even not do the survey and, go down 5 feet or something. But clearly there's no reason to stop the demolition of the building so this project can move forward. Then, and I'm going to jump around with a few points if you don't mind to address some of the issues. Ms. Hobbs said that I had not cited any authority about the test being, unless the statute is meaningless without a waiver, you don't imply one. She actually cited the cases, as did I, in her own brief. In Dr. Grossman's reply and cross brief, page 25, she states this intent, meaning this implied waiver, is found, and she's quoting from a case, when the provision in question would be meaningless unless immunity were waived. That is the legal test, and she cites the cases. Wichita Falls, it's at 106 Southwest 3rd, 692, and then also Kerrville at 28 Southwest 3rd, 1. That is the legal test. Unless you find that the statute is meaningless without the waiver, you don't imply one. And then to follow up, let me give you the cite on that Barr versus RTC case, which is involving res judicata and issue preclusion. It is at 837 Southwest 2nd, 627. And we do that again, make sure I got it right. 837 Southwest 2nd, 627. It's a 1992 Texas Supreme Court decision. So
What was that site? What was that site again?
it is, the case name is Barr versus RTC. It's the Resolution Trust Corporation. And then site is 837 Southwest 2nd, 627. In the 1992 Texas Supreme Court decision.
Thank you.
So the RTC, there's no question about it. That's the state agency that grants permits for archaeological surveys. It has broad discretion in how those surveys to be done. And once a permit has been issued, the city must follow and comply with the permitted scope of work. Here, if Dr. Grossman were really interested in anything other than delay, if he were really interested in there being some change in the scope of work, he's got an archaeologist, Dr. Carmichael. He could submit a proposed revised scope of work to the THC and ask them to approve it. And if he wants to do that, he's welcome to do that, and we will abide by whatever decision the THC decides to make. But we have no obligation to do that. We have an approved permit. And again, it is true. If we were to do a revised scope of work, we could not follow that. We have to follow what's been permitted. It violates the law for us not to follow what's already been permitted.
So let me understand. Because you don't have an obligation and you've been issued a permit, you will not go back to THC to ask for a permit that will encompass the suggestions or recommendations or the relief that Mr. Grossman, Dr. Grossman is seeking.
Let me explain why we won't do that. One is he wants the buildings not to be demolished. The buildings need to be demolished so that we can do the ground penetrating radar survey. You can't do a ground penetrating radar where buildings are standing. So we're not going to ask for that, no, because the ground penetrating radar is critical to finding artifacts from different eras.
Okay, hold on. So what I'm understanding from you is that in this lawsuit, your understanding is that of the relief that they're requesting is that they're requesting for certain specifics in the archaeological review, but part of that is they are still arguing that the buildings should not be demolished?
Yes.
That doesn't make any sense. That is what you're saying.
That is what they're saying, and it doesn't make any sense. That's correct. They're saying
in this lawsuit, I understand that that's been their position in the prior lawsuit, but you're saying in this lawsuit.
In this lawsuit, Dr. Carmichael is saying you should not do a ground penetrating radar because it's not effective to find Native American artifacts. And if you're not doing a ground penetrating radar, then you should not demolish the buildings. We're doing a ground penetrating radar. The THC has told us to do it, and it's necessary to find other artifacts, even if it doesn't help us find Native American artifacts. That's one. Then he says he wants a specific plan on how we're going to excavate for Native American artifacts. We're not going to do that because we're not only looking for Native American artifacts. We're looking for others, and the plan is variable and allows for adjustment depending on what you find. We're not going to do a plan that calls for very specific excavations at specific depths because we don't know what will actually be there. But they will use their expertise, and they will consult with the THC and do what is right in terms of excavation at the right depths. The third complaint is about the screens, and he says we should choose a smaller screen for Native American. We may well do that. We have the broad discretion within the scope of work to do it. But there are other depths when the other size of screens are appropriate and are effective. And so we're not going to ask to change those things. They will make our scope of work worse, not better. But if Grossman thinks they're better, let him make those applications to the THC, and they can revise the permit if they think that's in the best interest of finding.
And counsel, please correct me if I'm wrong, but I thought the way this process would work is the buildings go down, you do the ground penetrating radar, and then you do these trenches at whatever depth. And then whatever you find, then you put that into some sort of report, and that goes back to the THC. And then there's some collaborative process where I guess this third step is the THC tells you then what further to do, if anything.
Yes, and actually they will go to depths. Dr. Mangum, sorry, I keep using the wrong article. Mr. Mangum has said they're going to go to the depths of anticipated excavation for the actual construction of the facility. We don't know what that is, but it's likely to be 30 feet, probably, and possibly deeper than that. They will go that far. What happens is you vary the excavation as you go, but in terms of what you find, you're exactly right. Some things you find, you remove, and you preserve those in museums and things. Other things, for example, and I've learned a lot more about this than I knew before. Don't think I knew any of this before, but for example, if you found the remains of a riverbed, you can't remove the remains of the riverbed, but you digitally take all of that information down, exactly where it was, the width, the depth, and how far deep down. You preserve all that. So again, it gets published in papers and the information is preserved. But all that's done in consultation with the THC. But I want to make sure you all understand, even if you went down, say 5 feet and found nothing, that doesn't mean you stop. You keep going down to the depth of the excavation for the facility. Like each example, if your building were going to have a basement, you go down past the depth of the basement, because if you didn't, you might destroy artifacts during the construction, and the goal is not to let that happen. So if you look at, Judge, am I reading this correctly? Do I have 4 minutes left?
4 minutes and 50 seconds.
Thank you, Judge.
You don't have to use it all.
I won't. I'm just trying to keep track. Let me turn to one issue first, and that is the Seaboard decision, which is the only case that Ms. Hobbs cites about reversing the denial of a request for a temporary injunction. In that case, first off, you had one of the reasons for it was you had a building that was found to be historical by the United States government. And secondly, the action that was pending was a foreclosure. As a matter of law, there was irreparable injury threatened because a foreclosure would involve a sale of the property and it would change hands in terms of ownership. So there's no question as a matter of law there. Here, there's more probable evidence that going through the scope of work that's been permitted, that's been approved by the experts at the THC, including the state archaeologists, that will locate, protect, and preserve the Native American artifacts. Certainly, there's disputed evidence on that, which means the court's decision should be affirmed. But very interestingly, Seaboard does say, take a look at the equities. And the reason you do that, as Ms. Hobbs said, is because an injunction is a request for equitable relief. Well, one of the requirements is that if you're coming to the court asking for equitable relief, you have to come before the court with clean hands. That is not the case here. We addressed that in our brief, but I want to bring one particular aspect of this to the court's attention because it has never been addressed by Grossman in his briefing. One of the declarations that was submitted to the THC was from Dr. Babcock. That declaration was also submitted to the trial court and formed the basis for the trial court's granting an ex parte TRO before the temporary injunction hearing. In his declaration, Dr. Babcock references the permit, Moore's research design and scope of work, and then Babcock states that in his opinion, Moore's research design is invalid. Then he was deposed. In his deposition, he said he did not know the city was trying to conduct an archaeological survey. He did not know the city had obtained the permit. He did not know that the permit allowed the demolition of the buildings. He had never seen Moore's scope of work. He'd never seen Moore's research design. He admitted it was a false statement that he had reviewed Moore's research design. And once he was informed of the actual facts, he said he was satisfied with the THC's decision to reinstate the permit. Once he learned of Dr. Babcock's misleading and false declaration, consider what Grossman did and did not do. Dr. Babcock's deposition was taken because he was one of the witnesses Grossman identified as someone he would call at the temporary injunction hearing. Grossman did not call Dr. Babcock as a witness. He did not inform the trial court of the problems with Dr. Babcock's declaration. He did not seek to withdraw Dr. Babcock's declaration. Instead, when the city offered the deposition testimony of Dr. Babcock into evidence, Grossman objected to the admissibility of his own expert's testimony. In addition, another one of Grossman's experts was Dr. Romo. Grossman provided Dr. Romo's declaration to the THC and to the trial court as well. In his declaration, Dr. Romo referenced the city's permit and the fact that it had been suspended by the THC. In his testimony at the temporary injunction hearing, Dr. Romo admitted that when he signed his declaration, he had never seen the permit and he did not know that it had been suspended by the THC. Finally, both Dr. Babcock and Dr. Romo testified that Grossman had drafted their declarations for them. Not disclosing, let me back up. Errors and false statements in declarations presented to trial courts and state agencies are bad enough. Not disclosing those facts once they're learned of, but instead trying to conceal them by preventing their admissibility. That is exactly what is meant by unclean hands, which can form the basis of the trial court's exercising its appropriate discretion and denying a request for equitable relief, in this instance, a request for a temporary injunction, then the decision of the trial court can be affirmed on that basis alone. Finally, on behalf of the city, I implore you to look at the bigger picture in this case as well. In the summer of 2017, the city filed the ex parte City of El Paso suit in Austin to clear the way for this voter-approved MPC project. Grossman intervened.
Counsel, I hate to interrupt you, but it sounds like you're starting kind of into a new argument right there at the end of your time. But I do appreciate the argument for all counsel, and I appreciate your patience in working with us on this Zoom project that the Office of Court Administration has been so helpful for. And we do appreciate your excellent arguments and your excellent briefs, and the case will be submitted on that basis.
Thank you, Judge.
Thank you.